We have a huge victory that came out of a federal district court in Virginia in a case versus the ATF surrounding American adults aged 18 to 20 years old who are prohibited from a right just because of an age, a number, a blanket prohibition just because of a number. And this case is absolutely phenomenal. I just finished reading it. There's like 70 some odd pages. And I want to tell you all about it. But I also want to say that I have noticed the video I did this morning, check it out if you haven't already, has some people butthurt. I've already lost almost 200 subscribers for telling you the truth. I will tell you guys and gals that if you're watching this channel, you will only get the truth. I will never sugarcoat anything for you, whether it's related to Donald Trump or Dianne Feinstein. So if you want to say that I'm a bad person for showing you what somebody said, or you no longer want to support me or some of my businesses because of what that guy said, hey, then the problem's not, I guess, with me. But never follow somebody blindly, and never act the same way we criticize the left for acting, because that's what some people, based off their messages, that's what they're doing. Can't talk about our guy. He can never do anything wrong. Well, here he is in his own words. Now you're the bad guy. I don't know. All right, off my soapbox. Let's get into this decision about 18 to 20-year-olds that is phenomenal. Absolutely phenomenal. The way this judge wrote this decision is chef's kiss. It's great. Here's page 1. The case is the Frazier versus ATF case, and here's the memorandum opinion real quick. This matter is before the court on the defendant's motion to dismiss plaintiff's First Amendment complaint and the plaintiff's motion for summary judgment. For the reasons set forth below, the defendant's motion to dismiss the plaintiff's First Amendment complaint will be denied, and the plaintiff's motion for summary judgment will be granted. Let's start with the background of the case, just so you know what's going on. Plaintiffs John Corey Frazier, Joshua Clay McCoy, Tyler Dalton McGrath, and Ian Fletcher Shackley, the plaintiffs, want to buy handguns. All 4 men are over the age of 18 but less than 21. Federal law prohibits them from purchasing handguns from federal firearm licensed dealers solely because of their age. They are all law-abiding, responsible adult citizens who are otherwise qualified to own a handgun, and but for the laws at issue, they would purchase a new handgun and handgun ammunition from a federally licensed firearm dealer. In District of Columbia versus Heller, the Supreme Court recognized that the Second and 14th Amendments protect the rights of ordinary law-abiding citizens to possess a handgun in the home for self-defense. In Bruin, the Supreme Court held, consistent with Heller and McDonald, that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. And importantly for today's case, the Supreme Court in Bruin clarified the proper framework for analyzing asserted violations of the Second Amendment caused by regulatory statutes. Specifically, Bruin explains, "We reiterate that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command." In other words, Bruin requires 2 distinct analytical steps. First, it must be determined if the Second Amendment's plain text covers an individual's conduct. If it does, the Constitution presumptively protects that conduct. Second, if the conduct is presumptively protected, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. To do so, the government must affirmatively prove that its firearm regulation is part of a historical tradition that delimits the outer bounds of the right to keep and bear arms. Now, the judge does a huge part of proving that 18-year-olds are part of the people that the Second Amendment applies to and that the Constitution applies to. And after proving that, he uses that to just destroy the ATF's argument, and it's awesome. Today, many of the rights and responsibilities of citizenship fall upon the shoulders of 18-year-olds. At 18, individuals receive the franchise, the most fundamental symbol of membership in the political community. Voting is a key right of citizenship, but with it comes various obligations. When young men turn 18, they are required to register with the Selective Service. 18 is also the age that individuals are eligible to enlist in the military without their parents' or guardians' permission. Likewise, individuals become eligible for federal jury duty at 18. And at 18, they lose the Eighth Amendment's shield from the death penalty and become fully answerable for their crimes as adults. These examples teach that upon achieving their 18th birthday, individuals have gained admittance into the political community. It is, of course, true that some privileges of citizenship are denied to individuals under the age of 21. To the continued consternation of college students across the country, the drinking age remains 21. And Congress recently raised the age to purchase tobacco products to 21. These delayed privileges of citizenship are distinguishable from the right to keep and bear arms because that right is enshrined in the Constitution. There is no similar constitutional right to consume alcohol or to use tobacco. Therefore, when it comes to controlled substances and health, legislatures constitutionally may regulate these matters within reason, and their determinations are due significant judicial deference. If the court were to exclude 18 to 21-year-olds from the Second Amendment's protection, it would impose limitations on the Second Amendment that do not exist with other constitutional guarantees. It is firmly established that the rights enshrined in the First, Fourth, Fifth, Eighth, and 14th Amendments vest before the age of 21. Under the analytical framework established in Bruin, the government simply has not met its burden to support the finding that restrictions on the purchasing of firearms by 18 to 20-year-olds is part of our nation's history and tradition. Founding-era militia laws provide circumstantial evidence that 18 to 20-year-olds could purchase, own, and use arms. These militia laws and the cases interpreting them further support the finding that 18 was the age of majority for acquiring and possessing firearms in the founding period. There is no direct evidence of age-based firearms restrictions. The government, the party which bears the burden, fails to point to any founding-era laws to support the challenged law and implementing regulations. The only laws it can point to date from more than a half a century after ratification, and that does not discharge the burden that Bruin imposes. Because the statutes and regulations in question are not consistent with our nation's history and tradition, they, therefore, cannot stand. Plaintiffs also challenge these regulations on equal protection grounds. As these motions are decided on Second Amendment grounds, there is no reason to conduct an equal protection analysis. The conclusion: for the foregoing reasons, the defendant's motion to dismiss plaintiff's First Amendment complaint will be denied, and the plaintiff's motion for summary judgment will be granted. And this is Judge Robert E. Payne, the senior United States District Judge for the Eastern District of Virginia, the Richmond Division. Now this is huge. This will probably be challenged because we now have several circuit courts that are split, several federal district courts that are split, and that's typically when things get fast-tracked to the United States Supreme Court. Based on Bruin, boys and girls, there are no ways that the government can hold this. They can't stand. It's going to get destroyed. And another argument, I'll pin I'll put the link to this decision in the description because I think it's a great read. Everybody should read this. One of the arguments that the ATF posed was like, oh, it's not really a ban because, you know, the law allows their parents to get guns and they can let their kids use guns to learn and stuff, and they could always buy from a, you know, face-to-face transfer, you know, from a non-FFL. But they're trying to ban that too, right? They're trying to, universal background checks would get rid of that too. So this is a great case. This judge is on point. Hammered them, destroyed them. ATF takes a big L. We'll see what happens here. But good on this judge, man. Good on Clarence Thomas and the Supreme Court and this decision, the Bruin case. We're winning because of it, and it's wonderful. Let me know what you guys and gals think down below. If you haven't seen my video from this morning, give it a watch. But do it with an open mind and try not to be a sheep, because the truth needs to be said, even about people that we might want to lead the country. They don't have to be 100% perfect. They do have flaws. And when it comes to the Second Amendment, my job is to point them out. I'll see you all in the next one. Be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. Let me know what you think. Take care.